Welcome back. This is Eleissa Lavelle. I have been an arbitrator for several years after having practiced law for more than 35 years in the state of Nevada. And today I'm going to talk to you about alternative dispute resolution processes, this one being arbitration. The reason it's alternative is because it's alternative to the typical dispute resolution process that most people employ, which is going to court, going to litigation. Arbitration is very similar to litigation in that it is an adversarial process and that there is a decision maker who will rule either for or against parties based upon whatever they submit their disputes to be. But it is also a vastly different process, and primarily so because the parties get to choose what this process is going to be. They're going to design the process to suit the dispute that they are encountering with their clients' needs, and how all these issues can best be resolved. So you get to do that in arbitration, whereas you don't get to do that in litigation, which is run by judges, God bless them, and according to the Nevada Rules of Civil Procedure or the Federal Rules of Civil Procedure. In arbitration, the lawyers pick the rules. The lawyers design the process. So it's a much more flexible a way to get disputes resolved and conflicts managed. So arbitration is, I guess, can be defined as a private process of dispute resolution where the parties get to pick the arbitrator who issue a written award that can be confirmed and enforced just as a judgment. Once the award is rendered, it can be taken to court in a jurisdiction in which the parties have assets and enforced in that jurisdiction, provided that the arbitrator has done the job that they're supposed to do in rendering the award and the parties have done what they're supposed to do in getting the case to arbitration. Arbitration is probably one of the oldest dispute resolution processes that exist. It's been around in the United States since colonial times, and it is the dominant dispute resolution process for many kinds of cases, typically construction, international disputes, labor disputes, but virtually any case can be arbitrated. Any dispute can be arbitrated. The way that people get to arbitration is by agreement. This is where it differs. You may not agree on how the dispute is going to be resolved, but in a contract or even after litigation is commenced, the parties will have agreed to submit their disputes to arbitration. Now, the benefit, again, as I've said, is that you are in control. And what are you in control of? As the lawyer, if you are fortunate enough to have drafted the arbitration clause, you will have had the chance to choose and select and define what rules are going to govern the arbitration, what choice of law is going to govern the arbitration and the dispute, how the arbitrators are going to be selected, whether there will be one or three arbitrators, where the arbitration is going to take place, and design the process to suit precisely the disputes that you think are going to happen in this process and how they're going to get resolved. So you are in control and your clients are in control right from the get-go. An arbitration decision is binding. It is not something that the parties agree upon. It is binding. Once the arbitrator has ruled, it becomes final. It is not appealable, except in very rare circumstances. There are certain rules that authorize limited kinds of appeals. But generally speaking, once the arbitration decision is made, it is final. It can be challenged, but only on very, very slim kinds of facts. If the arbitrator is biased, and it can be demonstrated, if the parties have not had a fair opportunity to present their cases, the arbitration decision can be challenged. But other than that, arbitration decisions can't be challenged if the arbitrator just gets it wrong. So it's up to the lawyers to present their case in the same way and with as much clarity and research as they would in court, and it's up to the arbitrator to do the necessary work to make the correct decision and to articulate that decision in the award so everybody understands why the decision was made the way it was. So although it is similar to litigation, it's not quite the same thing. Let's talk for just a minute about the benefits of an arbitration. As I've said before, the parties are in control. You design the process. And the biggest benefit that you have is that you get to choose the decision makers. This is forum shopping at its finest. You decide in your arbitration agreement if it's going to be one arbitrator or three, and you get to select, with the consent of the other party, who the arbitrator is going to be. You can decide whether that arbitrator is going to have particular expertise. For example, in construction arbitrations, you might want somebody who has experience in construction. In a personal injury arbitration, you may want somebody who is experienced with those kinds of cases. In addition to the subject matter expertise, you're also going to want somebody who has process expertise. And as I've said, the arbitration process is a little bit different than litigation. Rules of evidence, for example, don't apply. Widespread discovery perhaps may not apply. The way that the arbitration is conducted is a little bit different. So you're going to want somebody who's had some experience with arbitration and understands the process as well as the subject matter. So let's talk a little bit about choosing the arbitrator. There might be rules in your arbitration clause that specify how the arbitrator is going to be selected, from which panels the arbitrators might be chosen. They don't have to be on a panel. They can be a private lawyer, or they can be a person who's in the industry. You get to choose that in your arbitration selection process, provided it's in your contract, or you can agree with your opposing party as to how that arbitrator is going to be selected. One of the other big things that you get to choose, and that's very important, is the rules that will apply. Much like the rules of civil procedure, the arbitration rules that you select will govern the process. They will control such things as the kinds and amount of discovery, how motion practice will be handled, whether or not experts will be allowed and how experts will be handled, whether or not there will be cross-examination of witnesses, when the arbitration needs to take place. All of these kinds of process rules will govern the actual administration process of the arbitration that the parties and the arbitrator are required to follow in conducting the arbitration. So the selection of the rules is something that the lawyers really need to spend some time with if you are drafting the clause that submits the case to arbitration, or if you are trying to reach an agreement with the opposing party. Read the rules. There are lots of different rules. JAMS, for example, has many different arbitration rules. AAA has different arbitration rules. The UN has developed arbitration rules for international commercial arbitrations. FINRA has developed rules governing financial disputes. There are many, many different kinds of rules that you should familiarize yourself with, including Nevada statutes and federal arbitration rules. So as you are selecting which process that you want to employ that is going to best serve your client's needs, you pick the rules that are best suited to accomplish these purposes. That's another thing that is within the control of the parties right at the front end and as you continue. You decide who's going to administer the arbitration. That's not the arbitrator. It's sort of like the clerk's office. The party that administers the arbitration accepts the arbitration demand, may help schedule the arbitration hearings, accepts the submissions, and generally does the kinds of things that a clerk's office will do, except that you will have private contact, first-person contact with those administrators and be able to discuss with them your needs and the needs of the dispute. You should know that the selection of the rules doesn't necessarily govern who you can select as an arbitrator. So even if you are looking at an agreement that says that Federal Arbitration Association rules apply, Federal Arbitration Act rules apply, that you can select a private arbitrator or an arbitrator that's sitting on a different panel. The rules don't necessarily govern who the arbitrators are going to be. That's up to you. So what are the other benefits of arbitration? Neutrality of the arbitrator. All of the rules and the statutes of the various states spend a great deal of time on making sure that those arbitrators that you select are unbiased. There are disclosure requirements. You're going to know when you select an arbitrator whether that individual has had any prior dealings with opposing counsel, with any of the parties, with any of the witnesses. You can assure yourself that the arbitrator or arbitrators that you select are going to be completely neutral and unbiased in the litigation, in the arbitration. Another benefit is that arbitration processes are more informal. You have more accessibility to the decision makers. The hearing times can be flexible and accommodate the needs of the parties. If you need to take a break, if there needs to be a space of a couple of weeks between the commencement and determination, whatever parties need to make this process more accommodating to them, the arbitration process is designed to help. Arbitration is usually much faster than going to trial. Generally speaking, it may be, although it may be a fairly short time for dispositive motions to be heard in court, getting to trial may take a year, 2 years, 3 years, depending upon the court dockets and your particular dispute. Arbitration is designed to be much quicker. Generally speaking, an arbitration hearing is conducted within probably 6 months to a year from the time that the demand is first submitted. And once again, that is within the control of the parties to decide. Sometimes people want continuances that they need because parties can't be available, witnesses can't be available. It's much easier to accommodate those requests in arbitration. Arbitration initially and hopefully is going to be a more cost-effective process. Are you going to pay the arbitrators? Yes. But the idea of arbitration is that because there is process and subject matter expertise, that this arbitration is going to be much faster and ultimately more cost-effective than if you go to trial. You're not going to have the continuances. You're not going to have the need perhaps to educate a jury that you would normally because your arbitrator is going to have, if you selected an arbitrator with subject matter expertise, that arbitrator is going to have a good understanding of the baseline situation that they're being confronted with and won't need to spend as much time educating themselves. Arbitration is good for sometimes even preserving business relationships. Litigation can be very contentious, and sometimes the longer litigation goes, the more contentious it becomes and the more hardened people become in their positions with each other. And they tend to sometimes grandstand. Parties will grandstand, lawyers will grandstand, and arbitration, because of its confidentiality and privacy, eliminates those possibilities and lets people just get to the heart of the dispute, present their cases, get a decision, and move on. And as I've said, finality is a big part of this. Lots of people just want this to be over. A big reason that cases settle is because they don't want to be litigating forever and ever. And while that's a good outcome, sometimes they can't settle and they're stuck with going to trial and going to appeals and it just taking much longer than they want. Arbitration resolves those issues. Once it's over, it's over. And for some disputes, that's exactly what parties want. Not always, but for some dispute, it's the right process to achieve that benefit. So how do you make sure that your arbitration is going to be of greatest benefit to you and your clients? First of all, as I've said, if you have an opportunity to draft your arbitration clause, think about the kinds of disputes that your parties are going to be involved with. Draft your clauses very carefully. Don't just pull something off the shelf that's been used in other disputes. Think through what you think your clients are going to be facing as the contract continues and how they are going to want to resolve these disputes should they develop. You're going to prepare for arbitration much like you will for trial. So have your evidence in place, have your witnesses in place, but understand that the flexibility may allow you to use deposition testimony instead of live testimony, to have affidavits instead of live testimony. The rules of evidence don't apply, so hearsay testimony may be available. So it's going to be a much easier way to prove the case, although the arbitrator is still going to evaluate the evidence and make determinations based upon the weight that will be given. But there's a little more flexibility involved, know how those rules apply and how you can benefit from them and how you can help your clients benefit from them. Know the rules. We've talked a little bit in the selection process about the rules, but those rules can be used throughout the arbitration process in the way that you conduct discovery, in the way that you submit motions, and in the way that you go forward with presenting your case. And finally, prepare your clients for the process. Help them understand what they're going to be facing, what their needs are going to be, how arbitration can help them accommodate those needs, and communicate with the arbitrator. That's, as I've said, one of the great benefits of arbitration is that you've got almost constant accessibility to the arbitrator, and the arbitrator should be able to understand and help your client get through the resolution process. Thank you.